Question to you.
I'm not aware of any interceptions of the Trump campaign.
And are you aware of any intercepted communications of any other candidates or campaigns?
No.
Okay, because earlier when Chairman Graham had asked you that, I thought you declined to answer, so perhaps I misunderstood that exchange.
And I may have misunderstood the question. I thought the question I declined to answer was a different one than that, so I'm glad I got a chance to clear it up.
Okay, so you have no information of any interceptions of the Bernie Sanders campaign, the Hillary Clinton campaign, or any other candidate in 2016 or campaigns?
No.
Okay. Let's revisit the topic, Ms. Yates, that you and Senator Cornyn were talking about.
Okay.
Is it correct that the Constitution vests the executive authority in the President?
Yes.
And if an Attorney General disagrees with a policy decision of the President, a policy decision that is lawful, does the Attorney General have the authority to direct the Department of Justice to defy the President's order?
I don't know whether the Attorney General has the authority to do that or not, but I don't think it would be a good idea, and that's not what I did in this case.
Well, are you familiar with 8 U.S.C. Section 1182?
Not off the top of my head, no.
Well, it is the binding statutory authority for the executive order that you refused to implement and that led to your termination. So it certainly is a relevant and not a terribly obscure statute. By the express text of the statute, it says, quote, whenever the President finds that the entry of any alien or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem appropriate. Would you agree that that is broad statutory authorization?
I would, and I am familiar with that, and I'm also familiar with an additional provision of the INA that says no person shall receive preference or be discriminated against in issuance of a visa because of race, nationality, or place of birth. That, I believe, was promulgated after the statute that you just quoted. And that's been part of the discussion with the courts with respect to the INA, is whether this more specific statute trumps the first one that you just described. But my concern was not an INA concern here. It rather was a constitutional concern, whether or not this the executive order here violated the Constitution, specifically with the Establishment Clause and equal protection and due process.
There is no doubt the arguments you laid out are arguments that we can expect litigants to bring, partisan litigants who disagree with the policy decision of the President. I would note on January 27, 2017, the Department of Justice issued an official legal decision, a determination by the Office of Legal Counsel, that the executive order, and I'll quote from the opinion, the proposed order is approved with respect to form and legality. That's a determination from OLC on January 27th that it was legal. 3 days later, you determined, using your own words, that although OLC had opined on legality, it had not addressed whether it was, quote, wise or just.
And I also, in that same directive, Senator, said that I was not convinced it was lawful. I also made the point that the Office of OLC looks purely at the face of the document and, again, makes a determination as to whether there is some set of circumstances under which some portion of that EO would be enforceable, would be lawful. They importantly do not look outside the face of the document. And in this particular instance, particularly where we were talking about a fundamental issue of religious freedom, not the interpretation of some arcane statute, but religious freedom, it was appropriate for us to look at the intent behind the President's actions, and the intent is laid out in his statements.
Final, very brief question. In the over 200 years of the Department of Justice history, are you aware of any instance in which the Department of Justice has formally approved the legality of a policy and 3 days later the Attorney General has directed the Department not to follow that policy and to defy that policy?
I'm not, but I'm also not aware of a situation where the Office of Legal Counsel was advised not to tell the Attorney General about it until after it was over.
Thank you, Ms. Yates. I would note that might be the case if there's reason to suspect partisanship.
Senator Klobuchar.
Thank you. I want to thank you very much for your service, Ms. Yates, from beginning to end, your distinguished career as a prosecutor. And I just was putting this timetable together, and I realized that your second meeting, when you went over to the White House to warn them of General Flynn's lying and his connections with Russia, was the same day that this refugee order came out, and it was the same day that you had to leave the Justice Department. So when did you meet with the White House counsel on that day?
I met with White House counsel, best I can recall, about 3 o'clock in the afternoon on the 30th.
During that meeting, did anyone mention that this refugee order was about to come out to the acting Attorney General of the United States?
No, and that was one thing that was of concern to us, is that not only was department leadership not consulted here, and beyond department leadership, really the subject matter experts, the national security experts, not only was the department not consulted, we weren't even told about it. And I learned about this from media reports.
So you learned about it after the meeting at the White House counsel from the media?
Right.
And then it's true that during your hearing, then Senator Sessions, now the Attorney General, actually asked you if the views the President wants to execute are unlawful, should the Attorney General or Deputy Attorney General say no? And what did you say? And
I said, yes, the Attorney General should.
Okay. And then, moving forward here, as was mentioned by Senator Durbin, this order was after a lawsuit from the state of Washington and Minnesota. The court basically challenged the constitutionality of the order. The order is not taken effect, but what I want to get to right now is the fact that the administration then withdrew its request for an appeal of the court ruling blocking implementation of the same order, and then they changed the order that you would not implement. Is that
right?
correct?
And there were a number of important distinctions between Travel Ban 1 and Travel Ban 2. At the time I had to make my decision, for example, the executive order still applied to green card holders, lawful permanent residents, and those who had visas. There were a number of other distinctions as well. And look, let me say one thing.
I want to get on to.
Okay, sorry.
Go ahead, very quickly.
Look, I understand that, people of goodwill and who are good folks can make different decisions about this. I understand that. But all I can say is that I did my job the best way I knew how. I looked at this EO. I looked at the law. I talked with the folks at the Department of Justice, gathered them all to get their views and their input, and I did my job.
Okay, I appreciate that. Let's go to Russia. December 29th, this is the date that actually Senator Graham and I were with Senator McCain hearing about Russian interference, meeting with leaders in the Baltics, Georgia, and Ukraine. This is the date that the President expanded the sanctions against Russia, and this is the date that Michael Flynn reportedly talked to the Russians perhaps several times about sanctions. He then went on to not tell the truth to the Vice President. And one of the White House officials has described the notification that you provided warning them of this as a heads up. How would you describe a heads up?
Well, at the risk of trying to characterize it, we were there to tell the White House about something we were very concerned about and emphasized to them repeatedly it was so that they could take action.
So it was much more formal than just a simple, hey, this is happening. Michael Flynn did not resign his position as National Security Advisor until February 13th. That is 18 days after you went over there with the formal warning. And in particular, after they knew about this on January 28th, Flynn was allowed to join President Trump on an hour-long telephone call with Russian President Vladimir Putin. Do you have any doubt that the information that you conveyed to the White House on January 26th should have been made clear that Flynn had been potentially compromised by Russia, that this information was clear?
Well, the purpose in our telling them, again, was so that they could act and so that they could convey that information. So I would hope that they did.
If a high-ranking national security official is caught on tape with a foreign official saying one thing in private and then caught in public saying another thing to the vice president, is that material for blackmail?
Certainly.
Do you want to add anything to that, Director Clapper?
No.
Okay. I think it's pretty clear, and I think it's pretty clear why we've had this hearing today. I wanted to ask you, Director Clapper, a few things about just in general this Russian influence. When Director Comey was here last week, he said, I think that one of the lessons that the Russians may have drawn from this, he's talking about the election, the influence, is that this works. Those were Comey's words. Do you agree?
Absolutely, and as I said in my statement, the Russians have to be celebrating the success of what they set out to do with rather minimal resource expenditure. And the first objective was to sow discord and dissension, which they certainly did.
And when you look at this, in addition to the hacking into the DNC and Podesta's emails, all those things, we also had the fake news propaganda, which is referenced in the report. I believe it's $200 million. Is that all they spent in the scheme of things, something like that?
If that, which doesn't include government support to subsidies to RT.
And how does RT work when you look at the...
Well, RT is essentially a propaganda mouthpiece for the government, since the predominance of its funding comes from the government. The management is close to Putin, so it's as I say, I think a Russian governmental mouthpiece.
Ms. Yates, I'm asking you in your capacity as a former Attorney General and Deputy Attorney General, I'd ask this of Director Comey about the use of shell corporations. Now something like 50% of real estate deals over $5 million are now done with shell corporations. We're trying to push so that the Treasury Department puts more transparency. This is something that the European countries are working on right now, and I'm very concerned that this is another vehicle where money is laundered. I'm concerned about loopholes in our campaign finance laws as well, but could you address this just from your experience as a criminal prosecutor?
Sure, and those are all valid concerns. We're actually lagging behind other countries in the world, and we don't want to become a haven then, where you can have shell corporations that can be used for all sorts of nefarious purposes that can have national security implications as well as criminal implications.
Director Clapper, did you want to add anything to that? And again, this is why I believe an independent commission, in addition to the great work that's being done by this subcommittee and the Senate Intelligence Committee, which is so important, as well as the investigation, an independent commission would allow a panel of experts to go into the next election, go into 2020, where Director Comey had said, I expect to see them back in 2018 and especially 2020. Those are his words. Do you agree with that, Director?
Absolutely.
And that is why an independent commission would allow us to come up with some ideas on how we can stop this from happening again, whether it is how the media handle these things, how campaigns handle these things, how intelligence agencies, when they find out, handle these things, because we cannot allow foreign countries to influence our democracies. Do you agree, Director Clapper?
I certainly do, and I understand how critical leaks are and unmasking and all these ancillary issues. But to me, the transcendent issue here is the Russian interference in our election process, and what that means to the erosion of the fundamental fabric of our democracy. And that, to me, is a huge deal. And they're going to continue to do it, and why not? It proved successful.
Thank you.
Until they pay a price, I hope, which they will soon pay. Senator Sass.
Thank you, Mr. Chairman. Thank you both for being here. Director Clapper, how likely do you think it is that foreign intelligence services are trying to compromise congressional IT systems?
Well, I think that's congressional IT systems are a target and have been, and certainly I saw examples of that during my time as DNI, and this is one case where we expeditiously informed the Congress when we saw evidence of that. And again, that's not just Russians; there are others out there doing the same thing.
And what intel value would it provide to them?
Well, depending on the nature of the material that they purloined, it could be quite sensitive. Hard to make a general statement about it, but just as a general rule, it could be quite damaging.
And could you talk a little bit about the relationship between that particular intel gathering on legislators and the interface with propaganda campaigns, such as you say Russia? I've heard you testify in other places about Russia's activity among their near neighbors. What's the relationship between propaganda and direct intel gathering?
I mean, on the part of the Russians?
Yeah,
Well,
among their neighbors.
They would certainly use that as they have, and examples of that in places like Georgia and the Baltics, where they will turn evidence that or what they've gathered and use that as leverage, or if they can, to use compromat, the Russian acronym for compromised material, whether real or contrived. So there's all kinds of nefarious things they can potentially do if they gather information like that.
One of the unhelpful ways that we talk about this issue in the present context, in D.C.'s polarized context, is it's almost always retrospective about our election in 2016, and so it devolves into a shirts and skins exercise about what candidate you allegedly supported. Director Comey last week said that he expects, as Senator Klobuchar just quoted him, he expects the Russians to be back in 2018 and back with a vengeance in 2020. I think it would be helpful for the American people to understand what Russia does among its near neighbors now. So could you unpack a little bit more of how that works?
Well, if anything, in many ways, particularly those countries that were in the former Soviet orbit, which they still feel, shall I say, paternal about. And so places like Moldova or the Baltics, Georgia, they are very aggressive in using all the multitude of tools that were on Senator Whitehouse's checklist, wherever they can, however they can, to influence the outcome of elections towards candidates for whatever office whom they think will be more pliant with them, and of course.
Us some sense of the, without revealing classified information, the order of magnitude of their financial investment in these kinds of efforts. If you're a near neighbor of Russia and you've got your Army, Navy, Air Force, Marines, and you might have a little bit of an intel community and a little bit of a sort of intel ops, info ops.
And any reason to believe that might have been coordinated or intentional?
Well, I don't know about the latter, but I think some news outlets were probably unwitting of that. It certainly went on, but I can't say to what extent that was coordinated intentionally with certain news outlets.
And
again, that's a kind of in the domestic realm.
You said that the Russians will continue this behavior until we impose some significant costs. Could you speak briefly to what sort of actions you think we might take that would deter them from continuing this action?
That's a little over my labor grade as an intelligence guy. I thought the sanctions that we did impose, and I was part of that as part of the former administration, were a great first step.
Well, I'll simply say that I agree with you, and a bipartisan bill led by my colleague Senator Graham and co-sponsored by 20 senators, Republican and Democrat, would be a terrific next step. Ms. Yates, we've established in the course of these questions that on December 27th and 29th, former National Security Advisor General Flynn discussed sanctions with the Russian ambassador. So when the Trump transition team told the Washington Post on January 13th that sanctions were not discussed, was that false?
I understand that there have been news reports to that account, but I can't confirm whether, in fact, those conversations regarding sanctions occurred, because that would require me to reveal classified information.
Understood. So I have a whole series of questions about things that would have been untrue. Were that the case, you're not going to be able to answer any of those.
Not to the extent that it goes to General Flynn's underlying conduct. I can't address that.
Well, then let me move to that, if I might.
Sure.
On January 24th, you just testified that National Security Advisor Flynn was interviewed by the FBI about his underlying conduct, and that underlying conduct was problematic because it led to the conclusion the vice president was relying on falsehoods. What was that underlying conduct, and are you convinced that the former national security advisor was truthful in his testimony to the FBI in January 24?
Again, I hate to frustrate you again, but I think we're going to have to, because my knowledge of his underlying conduct is based on classified information, and so I can't reveal what that underlying conduct is. It's why I had to do sort of an artificial description here of events without revealing that conduct.
I understand that. On January 27th, you just testified that you discussed with White House Counsel McGahn 4 different topics. And one of them included the possibility of criminal prosecution of the former national security advisor, and what would the applicable statutes be. What applicable statutes did you discuss? And in your conclusion, should the national security advisor face criminal prosecution?
Senator Coons, I'm going to strike out here, because if I identify the statute, then that would be insight into what the conduct was. And look, I'm not trying to be hyper-technical here. I'm trying to be really careful that I observe my responsibilities to protect classified information. And so I can't identify the statute.
Okay. Do you believe the administration took your warnings seriously when you made this extraordinary effort to go to the White House and in-person brief the White House counsel on the 26th and 27th? Do you think they took appropriate steps with regards to General Flynn as the national security advisor, given that he remained a frequent participant in very high-level national security matters for 2 weeks?
Well, certainly in the course of the meetings, both on the 26th and 27th, Mr. McGahn certainly demonstrated that he understood that this was serious. So he did seem to be taking it seriously. I don't have any way of knowing what, if anything, they did. If nothing was done, then certainly that would be concerning.
So you don't know whether they took any steps to restrict his access to classified information, to investigate him further, up and until the Washington Post published information that made it clear that he had been lying to the vice president?
No, again, I was gone after the 30th, and so I wouldn't know if any steps had been communicated to the Department of Justice, but I was not aware of any, no.
Had you not been summarily fired, would you have recommended to the White House counsel that they begin further investigations into the national security advisor, or that they restrict his access to sensitive and classified information?
Well, it's a bit of a hypothetical. Had I remained at the Department of Justice, and if I were under the impression that nothing had been done, then yes, I would have raised it again with the White House.
Thank you, Ms. Yates. Thank you, Mr. Clapper.
Ms. Yates, Dr. Clapper, thank you both for your years of service to the American people. Ms. Yates, I want to start with you. You declined to support, to defend President Trump's executive order because you thought it was unconstitutional. Is that correct?
That's correct, yes.
Okay. And you believe that no reasonable argument could be made in its defense. Is that correct?
Well, I don't know that I would put it in that way, Senator. This was the analysis that we went through.
Okay. Let me stop you, because I've got a whole bunch of questions.
Okay.
I just want to understand your thinking from my perspective.
Sure.
Did you believe then that there were reasonable arguments that could be made in its defense?
I believed that any argument that we would have to make in its defense would not be grounded in the truth. Because to make an argument in its defense, we would have to argue that the executive order had nothing to do with religion, that it was not done with an intent to discriminate against Muslims.
Okay. So
and based on a variety of factors.
You were looking at intent?
Yes, and I believe that that's the appropriate analysis. And in fact, that's been borne out in several court decisions since that time, that that's the appropriate analysis when you're doing a constitutional analysis. It's to look to see, what are you trying to accomplish here?
Okay. Suppose instead of an executive order, this had been an act of Congress, would you have refused to defend it?
If it were the same act, yes. And in fact, the Department of Justice has done that in the past, for example, with DOMA,
Right.
the Defense of Marriage Act, when the Department of Justice refused to defend DOMA.
But that was a political decision, was it not?
Well, I wasn't at Main Justice at that time, so I can't speak to that, but that was another example of when DOJ did not defend the constitutionality of a statute in that sense.
But in your opinion, the executive order is unconstitutional.
I certainly was not convinced that it was constitutional, and given that I wasn't, and the import of this, I couldn't in good conscience send Department of Justice lawyers in to defend it.
Well, I want to be sure I understand. Do you believe it's constitutional or unconstitutional?
I was not convinced that it was constitutional. I believed that it was unconstitutional in the sense that there was no way in the world I could send folks in there to argue something that we didn't believe to be the truth.
So you believe it's unconstitutional?
Yes.
Okay. I don't mean to wax too metaphysical.
And if I can say, I can understand why you might be a little frustrated with the language here.
I'm not frustrated. I'm happy as a clam.
No, and here's the reason. Let me give you a little idea of the timing.
Okay, but let me stop you because I don't have much time. I got a lot of ground to cover.
Okay.
I don't mean to wax too metaphysical here, but at what point does an act of Congress or an executive order become unconstitutional?
Well, it all depends on what the act does.
No, but I mean, at what point is it become? I can look at a statute and say, I think that's unconstitutional. Does that make it unconstitutional?
I think the issue that we faced at the Department of Justice is to defend this executive order would require lawyers to go in and argue that this has nothing to do with religion.
But at what point does a statute or an executive order become unconstitutional? Is it some a priori determination? It becomes, I mean, I'm telling you what I'm getting at, and I don't mean any disrespect. Who appointed you to the United States Supreme Court?
I was appointed.
That determined, isn't it a court of final jurisdiction decides what's constitutional and not? In fact, aren't most acts of Congress presumed to be constitutional?
They are presumed, but they're not always constitutional. And no, of course, I was not on the Supreme Court. And I can tell you, Senator, look, we really wrestled over this decision. I personally wrestled over this decision. And it was not one that I took lightly at all. But it was because I took my responsibility seriously as acting Attorney General.
I believe you believe what you're saying.
Yes, I do.
I'm just trying to understand this is likely to come up in the future.
Well,
at what point does an executive order or statute become unconstitutional? When I think it's unconstitutional, or you think it's unconstitutional, or a court of final jurisdiction says it's unconstitutional?
I believe that it is the responsibility of the Attorney General. If the President asks him or her to do something that he or she believes is unlawful or unconstitutional, to say no. And that's what I did.
Okay, I get it. All right, let me ask you both a couple of questions. Can we agree, Director and Counselor, that the Russians attempted to influence the outcome of the election?
Yes, sir, absolutely.
Yes.
Do you believe that the Russians did, in fact, influence the outcome of the election, Director?
In our intelligence community assessment, we made the point that we could not make that call. The intelligence community has neither the authority, the expertise, or the resources to make that judgment. The only thing we said was we saw no evidence of influencing voter tallies in any of the 50 states. But we were not in a position to judge what actual outcome on the election.
How about you, Ms. Yates?
I don't know the answer to that. I think that's part of the problem is we'll never know.
Okay. Have you ever heard, the Russians have been doing this for years, have they not? I'm not minimizing what they did. I think they did try to influence the election.
It's absolutely true. As I mentioned in my opening statement, sir, they've been doing this since at least the 60s.
Okay.
The difference, however, was this is unprecedented in terms of its aggressiveness and the multifaceted campaign that they mounted. That's new.
Isn't it a fact that in 1968, the Kremlin, actually Service A, which was part of the AGB, attempted to subsidize the campaign of Hubert Humphrey?
I don't know the specifics of that. I didn't want to research that, but again, that certainly comports with what the Russian tactics would be.
Okay. Isn't it a fact that in 1984, the Kremlin tried to stop Ronald Reagan from being reelected?
Again, I'd have to do some research to verify that, but again, it certainly comports with what if they chose a candidate they, for whatever reason they had an aversion to, they would do that.
Okay. General Clapper, have you ever leaked information, classified or unclassified, to a member of the press?
Not wittingly or knowingly, as I said in my statement.
Classified or unclassified?
Well, unclassified is not leaking. Unclassified, that's somewhat of a non sequitur.
Have you ever given information to a reporter that you didn't want to have your name connected with, but you wanted to see it in the paper?
I have not. I've had many encounters with media over my career.
I'm sorry about that. How about you, Ms. Yates?
Now, other than situations where the Department of Justice would arrange, for example, for me to talk on background with reporters about a particular issue, to educate them about that, no, I've certainly never provided classified information, and that would be the only kind of background information.
Do you know?
And I've done the same thing, but certainly not. That doesn't include sharing classified information.
Do you know anybody else, a justice, who has ever leaked classified or unclassified information to the press?
No.
Ms. Yates?
No.
Okay. Thank you, Mr. Chairman. I went over. I apologize.
That's okay. Senator Lee.
Thank you, Mr. Chairman. General Clapper, Ms. Yates, good to see you again. Good to have you back here. Ms. Yates, I remember so well your confirmation
Sounds
here.
like it's one.
And I remember one senator just bearing in on you, tensely bearing in on you, saying, would you stand up to the President of the United States if you thought he was asking you to do something unlawful? He's demanding under oath for you to say, yes, you would stand up. And you told then Senator Jeff Sessions of Alabama that's what you would do. And it appears to me that you've kept your word. Apparently it's okay to keep your word depending upon who the administration is. But I'm proud of you for keeping your word. When the president tried to set a religious test for entrance into this country, something most first-year law students would say was unconstitutional, you said you weren't going to uphold it. I wish that Mr. Sessions and others had kept it as consistent in this administration as they did in the last. That's my editorial judgment. Now, you wrote to the Justice Department, I am responsible for ensuring that the positions we take in court remain consistent with this institution's solemn obligation to always seek justice and stand for what is right. At present, I'm not convinced that the defense of the executive order is consistent with these responsibilities, nor am I convinced that the executive order is lawful. Is that an accurate statement of what you said?
Yes, it is, Senator.
And you still feel that way today?
Yes, I do.
The White House claimed that you betrayed the Department of Justice. Do you feel you betrayed the Department of Justice?
No, Senator, I feel to have done anything else would have been a betrayal of my solemn obligation to represent the people and to uphold the law and the Constitution.
Was the White House trying to tell the Justice Department how to carry out that executive order?
Well, I didn't have a lot of discussion with the White House about this executive order. I'm sorry, sir, I don't entirely understand the question.
No, but I mean, did anybody from the White House try to direct the Justice Department how they should respond on that executive order?
Well, certainly there was discussion with the White House about litigation strategy, but that occurred, to my knowledge, over the weekend. But after the 30th, when I issued my directive, I was gone then that evening around 9 o'clock, so I don't know what other discussions occurred after that.
Well, one, I applaud you for keeping your word to then Senator Sessions, who apparently has a different standard as Attorney General. FBI Director Comey testified before this committee. He was told why he appointed a special counsel to investigate the Valerie plane leak back in 2003. He was Deputy Attorney General. Attorney General Ashcroft has recused himself. Several senior officials in the Trump campaign administration are connected to this Russia investigation. The Attorney General was forced to recuse himself. Do you think this is the kind of situation where we should do what then Deputy Attorney General Comey, as acting Attorney General, did in the Plame investigation and appoint a special counsel?
Well, Senator, I think that my successor, Rod Rosenstein, has a big job ahead of him, and I don't think I'm going to be giving him any advice from the cheap seats about how he needs to do it.
Okay, well, let me ask you this. We know that about General Flynn's vulnerability to Russian blackmail. Attorney General Sessions misled this committee about his contacts and had to change his testimony. The president's son-in-law and senior advisor also reportedly failed to disclose contacts on their security clearance forms. Do you have or did you have any concerns about the Attorney General, about Mr. Kushner, or other Trump officials' vulnerability to blackmail?
All of this information came to light after I was no longer with DOJ.
Did you have concern, though, while you were at DOJ that General Flynn might be vulnerable to blackmail?
Yes, I did, and expressed those to the White House.
And you said why you
feel